Okay, it looks like we got a good group of people here joining us today. I'd like to welcome everybody across the state of Texas. I know we have a lot of people from Texas Democratic Lawyers Association joining us today. I'd like to thank Rose with the party and Nicholas Spencer, the president of Texas Democratic Lawyers, for helping us get people involved from all across the state. And we are setting up chapters in every major city and in rural areas all across the state of Democratic Lawyers Associations. And if you're interested in setting up one in your area, contact Rose or Nicholas, and we'll put their info in the chat later. Before we get started on this really good program we have today, I'd like to announce that we're having our final CLE of the year, Wednesday, December 1st. It'll be a hybrid event, so we'll be live upstairs at Kim San if you feel comfortable going to an in-person event. Of course, we ask that everybody show their vaccination card and wear masks when they're not eating. And that will also be broadcast, and there'll be a Zoom link you can register for if you prefer to watch that from home. It'll also be recorded for later viewing. On December 1st, we are lucky enough to have Chad Dunn, who is the general counsel for the Texas Democratic Party and an expert on redistricting litigation, and Gary Bledsoe, the president of the NAACP, and our Clarence Darrow recipient from last year, will be presenting on redistricting. And that happens to be the same day as the SCOTUS arguments on the big abortion case, the Mississippi case. I believe those arguments are at 10 a.m. So we will definitely have someone provide a quick update and recap or commentary on that before we start the redistricting program. Before I turn the program over to our moderator, I'd like to introduce Otis, who has a few announcements. Otis with the party is doing a hell of a job, and we're here to support him in every way we can, and he needs our support, and he's got a few things to announce.
Thank you, Stephen, for having me on, and good afternoon, the Harris County Democratic Lawyers Association. I'm going to be brief. Y'all have a fantastic panel discussing abortion rights. I know these folks have been on the front lines with my time being in the legislature, so I want to be brief. First and foremost, as you all know, there was a big announcement I believe on Monday. I don't think any of us missed it in Democratic circles. We have a major gubernatorial candidate. Obviously, as you know, as our position, we don't endorse candidates in the primary because we have to administer the primary, but Federal Work will be having a rally at Discovery Green. I believe it'll start at 6 p.m. I believe at Discovery Green. You'll want to get there early. I'm sure it'll be packed. It'll be great to show enthusiasm and energy for our base. I'm sure there's going to be other people that are filing, but we want to get the ball rolling. These Republicans have started already with their shenanigans with the school board races, which, by the way, I encourage everyone to get involved. We have 4 HISD races that are in the runoff with Ann Sung, Holly Flynn Villaseca, Elizabeth Santos, and Sue Dygard for HISD. Please visit their websites and get involved. And then last but not least, also to always become a sustaining member of the Harris County Democratic Party. I've put a link in the chat. We also need all of your help in volunteering with signature verifications and filing. As you all know, we're in the middle of the filing period that started November 13th. It'll end December 13th for folks who are filing to be on the ballot with verifying signatures. And again, just hands on decks and notaries as well too. So please email Nicole Peterson, who a lot of you are have a good rapport with, and she is our primary director on all things voting rights. So we look forward to you helping. And I just want to say this: continually make good trouble, continually make necessary trouble, continually make noise, because our fragile democracy absolutely demands it. Thank you all.
Amen, Otis, and thanks for all you do. And I'll be there tomorrow, and I'll see you tomorrow. Looking forward to that. So today, I'd like to thank the Center for Reproductive Rights for helping us put together an amazing program. Diamond has put together an incredible panel, including Planned Parenthood Center for Choice and AVOW, which is a Texas abortion advocacy group. I'm going to turn this over to our incredible moderator, who's a third year at UT Law, and she is probably going to be going to work for the ACLU after she graduates with the Reproductive Freedom Project in New York. And I'm very excited to hear her. And Zoraima, Liz, I'm going to turn it over to you. Thank you for doing this today.
Yeah, thanks, Steve. Welcome, everyone. My name is Soraima Pelais. I'm an abortion rights advocate and storyteller, and also a student at Texas Law. I have the pleasure of introducing today's event and our incredible panelists. But before I do, I wanted to take a moment to again thank our hosts, the Harris County Democratic Lawyers Association and the Center for Reproductive Rights for organizing this event. As y'all know, or will very soon come to learn, the state of abortion rights in Texas is dire. Texas has always been one of the most hostile states in the nation when it comes to providing and seeking abortion care. But on September 1st of this year, one of the most draconian laws in the nation, known as SB 8, went into effect here in Texas. SB 8 bans abortion starting at approximately 6 weeks of pregnancy and contains a novel enforcement mechanism. Instead of enforcement by public officials, the law empowers anyone, anywhere to sue providers, practical support networks, clinics, and others who help individuals access abortion care after 6 weeks. This law has decimated access to care. And as is the case with most other restrictions on abortion, its harmful impacts have fallen disproportionately on already marginalized and under-resourced communities. I have the great honor of also serving on the board of directors for Texas Abortion Fund, and our callers are members of these communities. They're Black, Brown, Indigenous, low-income, LGBTQIA+, and rural folks seeking abortion care in the state. Many of them were already struggling to navigate a web of restrictions like mandatory waiting periods, insurance bans, the list goes on here. And now many are being forced to travel hundreds or even thousands of miles to other states to access medical care that they should be able to get here at home. And for those who can't travel, they may be forced to carry pregnancies against their will. Texas has been living under this extreme abortion ban for 79 days. Each of those days sanctioned by a Supreme Court that refuses to step in and address the harm folks are experiencing here. But I'm glad we could connect with you all today to discuss not only the shifting reproductive rights landscape in Texas and in the US, but highlight some potential pro bono opportunities and chat with our amazing panelists, who are the folks who are actually working in the courts, the clinics, and on the ground here in Texas to improve our situation. There'll be some time at the end for a Q&A, but feel free to type your questions into the chat as we go, and I'll be sure to circle back to them. And with that, I'd love to turn it over to our panelists for today. Instead of me introducing each of you, could you each take a moment to introduce yourself? Say your name, your title, the organization you work for, and maybe just talk a bit about what you do. I'll start with you, Dr. Kumar.
Good afternoon. My name is Dr. Bhavik Kumar. I use he, him pronouns, and I'm a staff physician at Planned Parenthood Center for Choice here in Houston. And I've been providing abortion care here in my home state of Texas for about 6.5 years now. I grew up in Texas, and I've been in Houston for about 3 years. And in addition to providing abortion care, I'm also the medical director for primary and trans care at Planned Parenthood Gulf Coast, which is also in Houston. We have about 6 health centers throughout the greater Houston area.
Great, thank you. Molly, do you want to jump in?
Sure, so thanks for having me. My name is Molly Duane. I'm a senior staff attorney at the Center for Reproductive Rights, and I have been litigating abortion rights cases in Texas for the last 5 years, seemingly on a continuously endless loop. So I'm happy to be here today to talk about the litigation surrounding SB 8 and to take your questions.
Thank you, Molly. And Blake, if you could introduce yourself, but maybe also when you're done, just jump into your presentation. I'd love for you to kick us off on the substantive part of this conversation.
Great, thanks, Soraima. My name is Blake Rocap. I'm the legislative counsel at AVOW. I've been doing that work since 2009, which is 7 legislative sessions here in Texas. I'm also the legal director at Jane's Due Process, which helps young people navigate the parental involvement laws in Texas and get them connected with trained lawyers to get them judicial bypasses so they can get the care that they need if they can't involve a parent or guardian in that decision. The last time I was with you guys, it was before the June Medical Services case was heard at the Supreme Court. I think that was maybe 2 terms ago. Time has been weird in the pandemic, but we're on the precipice of another major Supreme Court decision on abortion, 2 actually, the decision in SB 8 and the decision in Jackson Women's Health. So since that time, the Texas legislature, as is its wont, has kind of ceaselessly added more restrictions to what was already a restrictive environment to getting care, like Zoraima said. So even prior to the Supreme Court allowing the most recent restriction to go into effect, Texas had some of the most restrictive abortion access laws, which led to patients having to wait a longer time because the physicians, like Dr. Kumar, had to comply with the law, which involves a mandatory 24-hour waiting period and a requirement that a patient receive a sonogram from the same physician that performed their abortion. And that creates a scheduling issue for the clinics, and it created a situation after the enactment of the law that was eventually overturned in the Holmans versus Hellerstedt case. The number of clinics in Texas was halved, and we still have around 20 clinics, whereas before that in 2013, there were 42 clinics. So the capacity to provide care is lower, which leads people to wait longer and makes it harder for them to schedule the care that they need. What you should know is that the legislature in its current makeup and with it and the state leadership, the current state leadership, will always be beholden to the anti-abortion forces unless there are political consequences for it. They will always do the thing that they think pushes abortion most out of reach within the bounds of the Constitution. And that goes as far as even, enacting laws that they know are unconstitutional to try to get the constitutional interpretation changed. So in addition to the Senate Bill 8 and the restriction at 6 weeks that Zoraima talked about, the legislature also finally passed a trigger bill. They've been trying to pass it for years and did it, which means that if the Supreme Court allows the right to abortion to be completely and wholly governed by the states and eliminates it as a federal right, abortion will be illegal in the state of Texas. And that's a distinct possibility after Jackson Women's Health is heard in 2 weeks, and the decision comes down next summer. During the pandemic, the governor and the attorney general conspired to also ban abortion under the guise of public health, using that public health crisis as an opportunity to enact their anti-abortion agenda. So until there are political consequences, the Texas legislature will continue to enact more and more restrictions as much as they can until the federal courts stop them, which that line seems to be further and further away with the current makeup of the judiciary.
Great, thanks, Blake. And I think just, so folks can get a sense of what the barriers are that already existed prior to the current moment. Could you elaborate a little bit more on maybe some of the parental consent laws or, medication abortion bans? I just, to give folks a little bit more of an idea of the web that people on the ground have to navigate.
Sure. So I saw a slide from the Guttmacher Institute about the 10 most common restrictions that states have enacted on abortion one time in a presentation they were giving. And Texas had 9 out of the 10. I had, everything, it was a few years ago, and it was everything but the trigger ban, which means that private health insurance often doesn't cover abortion care. There's no public insurance option to cover abortion care, both because of the Hyde Amendment and because the Texas legislature has forbidden local public health authorities from funding abortion care. The lack of clinics means that unless you live in an urban area in Texas, your closest abortion clinic is hundreds of miles away. And that is mostly where the access is because of the restrictions on physicians providing abortion. We no longer, we have very few, if any, physicians that provide abortion care in their own clinical setting outside of a licensed abortion clinic because those regulations are so, not, I don't know the right word, because there's so many regulations, it makes it impossible to do it in a normal setting. So basically, the legislature has done everything they can to restrict abortion access, which means people have to wait, people have to travel in order to get the care that they need.
Thank you. Molly, I can turn it over to you. I know you have some slides, so just go ahead and kick us off.
Sure. So thanks, Zarima and Blake, for that introduction and for grounding us in the situation in Texas in which SB 8 sits. So we're here today to talk specifically about SB 8, which I just wanted to mention briefly is similar to laws we have seen in other states in some ways, but also very different in many other ways. As Blake mentioned, SB 8 is a 6-week ban, which means that it prohibits abortion at a stage in pregnancy in which many patients don't even know that they're pregnant. And lots of states have passed laws like SB 8, and they have universally been enjoined or struck down entirely, as you can see on this map. So what makes SB 8 different? Well, it was designed in a blatant attempt to evade judicial review. And so the way in which SB 8 is structured is that instead of being enforced by state officials, so it's not a crime, physicians can't go to prison for violating it, and clinics can't lose their license for violating it. Instead, SB 8 creates a bounty hunting scheme where any person, truly any person in the world, can sue someone who provides an abortion in violation of SB 8 or aids and abets in the provision of such an abortion, and seek a bounty of a minimum, there is no maximum, of $10,000, as well as an injunction preventing that individual from violating SB 8 in the future. And the way in which these lawsuits are set up under SB 8 stacks the deck entirely against SB 8 defendants. So there's a lopsided attorney's fees provision, venue provisions, standing provisions that are all completely outside of the norm for Texas law. So there have been a number of legal challenges to SB 8, and I'm going to talk briefly about 4 of them and give you all an update about where each one stands. But spoiler alert, they're all still pending, and we're waiting for judges to decide in every single case. And so, as Zarima said, we're 79 days in and still without relief in any of those cases, which I think is important to keep in mind here. So the first case I want to talk about is Whole Woman's Health versus Jackson. This case was brought by a large coalition of abortion providers and abortion advocates in the state of Texas. And because of the unique enforcement mechanism of SB 8, we had to identify the right defendant to sue in that case. So the allegations that we made in that case are that the state cannot remove itself entirely from an enforcement scheme, and that state court judges, clerks, and even the attorney general are still necessarily involved in enforcing the law. So the defendants in that case moved to dismiss, and the district court ruled in our favor, saying, yes, you had indeed sued the right people. And what we saw from there was the Fifth Circuit putting a holding on that ruling, canceling the preliminary injunction hearing that we had scheduled just a few days before September 1st, when the law was set to take effect, and then slow tracking the appeal process. So what happened from there is that we went to the Supreme Court and asked the court to block the law while litigation continued, which they refused to do, meaning that on September 1st at midnight, the law took effect. However, a couple weeks later, the Supreme Court granted our request for cert, bypassing the Fifth Circuit and canceling further proceedings in that court. And so what happened from there, you're probably all aware, is that we had oral argument before the US Supreme Court on November 1st, and we're currently awaiting a ruling in that case. So you can't talk about Whole Woman's Health versus Jackson without also mentioning United States versus Texas. These cases have worked in tandem because essentially after the US Supreme Court failed to step in on September 1st, the DOJ filed their own federal case against the state of Texas on September 9th, requesting similar relief as we had requested in our initial case. What happened there is that the district court granted the DOJ's request for a preliminary injunction, and that injunction actually went into place for 2 days, meaning that abortion services were resuming across the state until, perhaps unsurprisingly, the Fifth Circuit put a hold on that ruling as well, meaning that abortion services once again were curtailed to the 6-week limit. From there, the Department of Justice asked the Supreme Court to either reinstate the injunction or hear the case on the merits itself. And in a very quick ruling on both the US versus Texas case and the Whole Woman's Health versus Jackson case, the Supreme Court decided to hear both of our cases in tandem. And so again, on November 1st, the court heard oral arguments in US versus Texas, and we are still awaiting a ruling on that case as well. So what's been happening in the meantime? Well, we haven't been quiet. We've been very busy. So there are also around 15 cases pending in state court alleging that SB 8 violates in addition to the federal constitution, violates the state constitution in a number of ways. And these cases originated from the fact that Texas Right to Life created a pro-life whistleblower website to collect tips for violations of SB 8, and pretty explicitly showed that they were threatening to enforce SB 8 against providers and individuals who aided in the provision of abortion. So a number of cases were filed against Texas Right to Life in state court. The history of each is a little bit complicated, but I'll just say that after securing temporary restraining orders in each of those cases, the cases were consolidated and transferred to a multi-district litigation court who held a TCPA motion hearing and a summary judgment hearing on November 10th. And so in that case, once again, we are awaiting a ruling, which could lead to a final judgment, a declaratory judgment that at least the enforcement provisions of SB 8 are unconstitutional. But those cases still have a long ways to go up to the Texas Supreme Court or beyond. So the last case that I'm going to talk about briefly is Braid versus Stilley. And this case originates from an op-ed that Dr. Alan Braid, who's a longtime provider of abortion in San Antonio. He's actually been providing abortion since 1972, before it was even fully legal in Texas. And he published an op-ed in early September saying that he had provided an abortion in violation of SB 8, essentially inviting lawsuits to be filed against him. What we saw from there is that while Texas Right to Life refused to sue him, presumably to avoid litigation of SB 8 through his case, 3 claimants did indeed sue him, including, curiously, 2 out-of-state disbarred attorneys, one from Illinois and one from Arkansas. And so what we have done from there is file a federal lawsuit in Illinois in the nature of interpleader, which is something that most folks probably haven't thought about since law school, if ever, that seeks to consolidate those cases because they are all seeking similar monetary requests. And there's a provision of SB 8 that says that an individual sued under SB 8 can only be liable for paying the $10,000 plus fine once for each abortion. So in that case, we were also seeking a declaration that SB 8 is unconstitutional under federal law. And much like all the other cases, this case remains pending at the motion to dismiss stage. So that is all a long way of saying we are still in a holding pattern in all of these cases, but I'm happy to answer questions that folks may have about any of the cases or about what the legal landscape will look like from here. So with that, I think I'm turning it over to Dr. Kumar.
Thanks, Molly. I forgot to mention in my intro that I've been a plaintiff in some of these cases, including the Whole Woman's Health case. But it's always nice to get a summary because there's so much going on all the time with abortion legislation and maintaining access that it can still be confusing for non-lawyers like me. So I'm going to shift gears a little bit and talk about the perspective of providing care under SB 8. And I'd say without a doubt that the last 2.5 months that SB 8 has been in effect have been the hardest and most trying in my career in medicine. It's the most extreme abortion restriction in the nation. And it's nothing short of devastating for me, my colleagues, and most of all the patients that we take care of. Moving back a little bit before SB 8 went into effect, we tried to see as many patients as we were able to, staying pretty late at the clinic until the evening hours. And people were anxious, folks were nervous, and they were desperate to not be pregnant. That day we saw over 60 people. They were all able to get safe and legal abortions, and everyone went home with a sense of relief that most people feel after their abortion. But the following day, on September 1st, I was forced to be an agent of the state for SB 8, and along with the nurses and the amazing staff that I get to work with, I saw people that were overwhelmed with emotion, with grief, and frustration in not being able to access the care that they needed. One patient in particular thought she was much earlier in the pregnancy than she actually was. She'd been using contraceptive pills, had regular bleeding throughout the pregnancy, that she thought was her period, and she had managed to get childcare for her 2 children at home and make it to the clinic that day for her ultrasound appointment. And she had to learn that she couldn't access abortion care anywhere in Texas that day. She was now facing the reality of traveling out of state during a pandemic, finding childcare for longer than she had anticipated, and all the other burdens that she would have to overcome just to get essential health care that she needed. And this is just one of hundreds of stories that tragically has become thousands since we've been forced to live under this cruel law. As it's been said already, it's been almost 3 months or 79 days today, and millions of Texans of reproductive age have been denied their constitutional right to decide when and if they have a child. We often talk about what will happen to abortion access if Roe is ever overturned, but the reality is in Texas, we've already been living in a post-Roe world. And for most states in the South and the Midwest, Roe is the floor. That protection is effectively meaningless here in Texas, where in the absence of safe and legal abortion care, thousands of people have already been forced to assume the burden of traveling out of state for healthcare or otherwise carry pregnancies to term against their will. And we know that throughout time, people have always sought ways to end their pregnancies that they cannot carry to term. Abortion access isn't a modern issue, but rather has become politicized by extremists, weaponizing abortion as a tool of oppression. The people that are most harmed by restrictions on abortion continue to be people of color, especially Black women, and low-income and poor people who make up 75% of those accessing abortion throughout the country. We also know that banning abortion doesn't stop the need of folks who need access to abortion, and it doesn't stop abortion from happening. It only drives people out of state, forces them to consider potentially unsafe alternatives, or coerces them to carry a pregnancy to term. And while some of the devastating consequences are immediate, the full impact of SB 8 will be revealed over time, including in the form of generational trauma. But this is not an experiment that we need to wait to see play out. We can look to other countries where abortion has been banned to see what will happen. Maternal morbidity and mortality rates will rise, more people will suffer in the pursuit of unsafe care, and families will be irreversibly harmed for generations to come. Having to deny people care and sending them home still pregnant hasn't gotten any easier since September 1st. Turning people away who need care is cruel. I went into medicine to take care of people, to make them feel better, and I've dedicated my life to that mission. Having to tell people I can't help them, or worse yet, that I could help them, but the government won't let me, feels disgusting and inhumane. My patients cry, they're confused, scared, upset, desperate to not be pregnant. I have no good answers for their questions. Questions like, why is this happening? What else can I do? When can I come back? Every day, my colleagues and I sit with people, real people with names and stories, and each of whom have reasons why they know they can't be pregnant. And every single day we have to look them in the eye, hear their pleas of desperation, and still tell them, no, I'm sorry, we can't help you. It's exhausting and devastating. And even on the best day, people seeking abortion care here have to contend with so much, a limited landscape of providers that Blake mentioned, medically unnecessary ultrasounds, 24-hour mandatory delays, parental consent laws, prohibitions on using Medicaid or private insurance, and there's so many other things that folks have to navigate. And all those things don't go away just because of SB 8. They're still navigating that on top of SB 8. We see patients who are survivors of rape and incest, patients who are still children as young as 11 or 12 years old and may not even understand how their body works yet, let alone how to navigate pregnancy on top of potential trauma or sexual abuse that they may have experienced. We've seen patients who are homeless, struggling with drug addiction, and they know that they can't support a child. Patients who fear pregnancy will tether them to an abusive partner, We've seen these patients walk into our health center who have used things that they found on the internet. Perhaps they didn't work, and maybe an excruciating pain from some of these things. And we also see people who are pregnant and just need to not be pregnant anymore. But no matter their circumstance, all these people have a right to control their own bodies and should have the freedom to determine their futures. But for 79 days, the state of Texas has robbed them of that right. And as healthcare providers, we've been robbed of something too. When we go home at night, rather than knowing that we've helped people who need us, we are instead worrying about what will happen to them. I worry about the patients who tell me they can't afford to leave the state. I worry about the patients who never even call us in the first place. And the last 2 months have been draining and heartbreaking. This state-inflicted trauma has to end, and every hour that SB 8's in effect, my patients continue to suffer. So we're desperately waiting for some relief. And I do fear that for some people, it's already too late. The way restrictions on abortion play out in real life show us that folks already navigating layers of oppression are harmed the most. That means Black women who have disproportionately high maternal mortality rates in Texas are at the center of this harm, along with low-income folks, young people, folks living in rural areas. It's important for me to name these restrictions on abortion access, including Senate Bill 8, as inherently racist and designed to further marginalize folks of color. Lastly, I wanted to just touch on the fear and stigma that I feel as an abortion provider in Texas, and I also see my patients facing. There's no other place in healthcare where I see such intimidation and harassment. For folks who are not comfortable saying the word abortion, I would encourage folks to say that word, that you lead with your values. You know, next week is Thanksgiving, and sometimes conversations happen. And so that's a great time to lead with your values and say the word abortion if you're able to, and remind folks that abortion access is a fundamental American right. So thanks to the legal community for supporting us and folks that do the work. And I remain hopeful for some decision, hopefully soon, that will allow us to take care of our patients again. And thanks for taking some time to listen to me today.
Thank you so much for that. As someone who's had an abortion, I can't say how thankful I am for the providers and the clinic staff out there that are taking care of folks who need that care. So thank you again, Dr. Kumar, and to our other panelists for all the work that you do. I do want to move to the Q&A portion of the conversation now. Again, if you have specific questions, please feel free to type them directly into the chat. But I can start us off with a question that was in the chat, and anyone feel free to respond to this, but it seems like maybe Blake or Dr. Kumar could maybe speak to this. What is the effect of the medication abortion law, SB 4, from the second special session that will take effect December 2nd?
I'd be happy to give you the dry legal analysis and then let Dr. Kumar tell you how it really affects his patients in the clinic. The major thing that SB 4 does is it limits physicians' ability to provide medication abortion at 7 weeks gestation or 7 weeks LMP, as opposed to what the FDA has approved, which is closer to 10 weeks. And I believe what is, safe based on the research, which is maybe further than that, but Dr. Kumar can certainly tell you that. It also prohibits the delivery of medication abortion outside of the clinical setting, which means it makes it more explicitly clear that if you help someone self-manage their abortion, you could be criminally liable for that, while at the same time, perhaps not affecting a person's ability to self-manage their abortion, because in their magnanimity, the legislature always excludes the pregnant person from any criminal penalties. But it does have criminal penalties for anyone who provides abortion-inducing drugs outside of the clinical setting and restricts the availability of that to pregnancies less than 49 days.
Yeah, I would just add from a clinical perspective that medication abortion has been around in this country for over 20 years now. And as you can imagine, there's advances in medications, there's advances in the way we practice medicine. So when it was first introduced, it was limited to 7 weeks, and now we can go to 11 weeks. But with this bill, what's happening is the state is telling us how to practice medicine and being very, very restrictive. Instead of taking an advantage of advances in medicine and new evidence and studies that show it's very safe, we're having to restrict that. And what's happening is where you live determines how and if you can access abortion, right? There's no medical backing to this. It's actually less safe to do it this way. But that's what the state is requiring. And it's not surprising that the state is passing laws that are harming my patients rather than helping them. And this is just another example of that.
I could add just one other point on that. What's really strange about SB4 is that Texas's existing law says follow the FDA protocol for medication abortion. And what Texas has done with SB4 is delete that and say, never mind, ignore the FDA, do this instead. It's just completely backwards when it comes to medicine.
And as a quick boo line, Senator Patrick, who's now Lieutenant Governor, carried that bill in 2013 and told everyone how important it was to follow the FDA protocol. And then he was a big champion of just absolutely deleting that line from the code, as Molly said, that the FDA protocol should be filed. So I know it's unfortunate.
Thanks, everyone. And I think Rita had a follow-up question to Molly's presentation about how the filing in Illinois state courts may affect the suit pending in Texan state courts, if at all.
Yes, civil procedure nerds always want to know more about the interpleader case. I keep saying, because I have to bring some lightness to this, obviously I don't live with it every day the way that Dr. Kumar does, but it sits heavy on me. But the way I infuse lightness into this discussion is by talking about the ways in which all of these cases are going to end up in law school textbooks one day. So the interpleader suit, our allegation is that, we have 3 different people who are all claiming that they are owed the same $10,000. And so by filing our federal lawsuit in the nature of interpleader, what we are asking for is an injunction to prevent those state lawsuits against Dr. Braid from going forward, while at the same time saying, actually, Dr. Braid doesn't owe anyone the money because the underlying statute is unconstitutional. So that's how the lawsuit is structured.
Great, thank you. Just going down some other questions from the chat here, or actually this is a question I had just generally about if the Supreme Court does allow the provider suit to go forward or the federal government suit to go forward, what happens after that? Where are we procedurally? And I think Molly or Blake or whoever can speak to this.
Sure. So the answer is a little bit different depending on which lawsuit goes forward. So in the United States versus Texas case, they already have a preliminary injunction from the district court that was stayed by the Fifth Circuit. And so if they prevail in the US Supreme Court, that injunction will automatically go back into place. In our lawsuit, Whole Woman's Health versus Jackson, we never got to the preliminary injunction stage because the Fifth Circuit canceled our hearing. So what we believe the most likely outcome would be if we prevail in the US Supreme Court would be that the case gets remanded back to the district court for us to hold that preliminary injunction hearing in the first instance. But the papers are all completely briefed. The judge, who's actually the district court judge, is the judge in both cases, and so has already written a preliminary injunction blocking SB 8. So our hope and expectation is that relief would come pretty quickly within days after a decision from the US Supreme Court if we prevail.
Thank you. And jumping back to an SB4 question, are there any plans for challenging that now? I'm not sure if we can speak to that, but I think there was a question about whether or not there was going to be a legal challenge to SB4.
So I can address that briefly and just say, obviously, I can't share conversations that I'm having with my clients about their plans for litigation. But I'll just note that because the primary effect of SB4 is to prohibit medication abortions at 7 weeks, which are abortions that are not currently happening under SB 8, it is difficult to challenge that law unless and until full abortion services resume in the state.
Thank you. And then we have a question about PMA nurses associations doing a follow-up on their strongly worded opposition to these acts. Maybe Blake, you can speak to that.
Yeah, thanks, Barbara, for that question. It remains to be seen, well, the TMA took down their last cycle of political endorsements for their PAC, which endorsed many of the proponents of this bill. They removed them from their website to escape accountability. They did very little during the legislative session to oppose the bill, and then, after the Supreme Court allowed it to go into effect, issued a very pearl-clutching statement. So I'm exceptionally disappointed in what they've done. The Nurses Association is on slightly different footing. I haven't seen a ton from them, but they also are not the political behemoth that the Medical Association is. So they have, they don't have a whole comms apparatus or policy folks or lawyers or anything. I have not seen much follow-up. So be looking out for what their endorsements look like in the coming election cycle, or if they let's try to hold them accountable for their poor performance at the legislature and their lack of consideration for their members like Dr. Kumar and the rest of their patients across the state that need abortion care.
And if I can just add to that, the statement that I read, unless I missed one, did not include the word abortion at all. And I don't think they've ever used the word abortion in any of their statements. So it was a very soft response, and it was too little too late.
Molly, did you want to jump in?
I was going to defend them a little bit. I won't give them too much credit, but they did submit an amicus brief supporting our case in the U.S. Supreme Court, which is something I don't think they've ever done before. So it's something.
Baby steps. I think this next question is for Dr. Kumar. Are there concrete ways that people can provide assistance to your patients? Of course, always donating to abortion funds is a great idea, but are there things that you notice that your patients need outside of those things that folks can do?
Yeah, that's a very common and tough question to answer. And I think the most helpful thing that folks can do right now is donating money to abortion funds, but also to practical support orgs. Folks definitely need help in paying for the care, which abortion funds can do, but then there's also travel, there's staying overnight for states that have mandatory delays of 24, 48, 72 hours, paying for childcare, gas, which is very expensive right now. And so a lot of these practical support orgs in Houston, it's CASN, CASN, which stands for Clinic Access Support Network, and they're helping with a lot of those things. And so for the folks that are able to work through the logistics, it's really financial tends to be the main barrier in figuring out a lot of these things. And then for the folks that are just like, I can't do it, it's, childcare and somebody to watch their kids and things like that. But I think, I don't know of any organized entity that's helping sort of help people figure that out and provide childcare. But obviously if they had the finances and the means, they may be able to overcome that barrier. So I think continue supporting that, your local abortion fund, and which is a little fun for us in Houston. And then if you can donate to practical support orgs, that's also useful.
Yeah, from a former organizer too, I would say it's really important to just absolutely always follow the lead of the organizations on the ground doing the work, instead of trying to, find your own way to contribute. All help is appreciated, but, I think that it's really important we take the lead from those folks.
I'll add one more thing. We've been trying to get creative to help overcome these barriers and obstacles. And so the city of Austin has put in their public health budget some money for practical support. And I know Harris County is looking at it. And so those Harris County commissioners and the county judge need to hear from you that you support them using county general funds and any ARPA funds that they have to help provide practical support for people that need abortion care, because they're going to get some backlash and they're a little skittish about trying to do it. So they need to hear from their supporters in their community that you do support them using county funds.
Did Blake freeze for folks? Yeah, okay. Well, Blake will come back to us, but great point about supporting. And I think somebody just asked in the chat about businesses. I'm not familiar with that, but I think if we can persuade our business, folks in Houston or other areas and associates to come out on the issue of abortion. I know Avow did something recently with the Los Verdes, which is like the fan club. Blake, you're back. you can talk about how Avow has worked to get businesses to help in the effort to pressure for change or local groups. And I know y'all done something with Los Verdes in Austin. So I wanted to shoot that back to you.
Yeah, we've really tried to broaden our advocacy to other already organized groups, including the soccer club's fan group Los Verdes, to get out the message and into other spaces that, you know, abortion rights are under attack and that our community supports abortion rights, and that we should talk about that support. We're also trying to hold businesses that have supported these anti-abortion politicians accountable. AT&T, of course, is the biggest political donor and hirer of lobbyists in the state of Texas. And so they have deep connections and continue to support the leadership and the elected officials that have done this. So we're trying really hard to model the great work that our friends in the LGBTQ movement have done in securing marriage equality, to have businesses hear from their employees and their constituents, their customers, that supporting anti-abortion politicians is wrong.
Thanks. Getting back to some questions in the chat, this one I think is geared at understanding SB8 a little more. How would a plaintiff, I'm assuming a potential SB8 plaintiff, prove that the patient was pregnant? The patient is not subject to the suit and they don't have the right to get the patient's records under HIPAA. So if somebody wants to explain how that would work a little more.
Sure, so I can try and tackle that a little bit. I mean, it's a little unclear. This is a creature of law that doesn't exist anywhere else in our legal system, which is, you know, the unique nature of this law makes it difficult to understand how it would work in practice. But I think something that folks maybe don't realize is that an exception to HIPAA is if a court orders a medical provider to turn over the medical records. So presumably the way that this would function is that a provider gets sued for providing an abortion in violation of SB8. The plaintiff in that case requests discovery, and then the court orders the doctor who provided that abortion to turn over the medical records. And that would not be a HIPAA violation because it would be turned over pursuant to a court order. So I mean, SB8 is scary in a lot of ways, obviously, but I think something that flies under the radar here is the threat to privacy that patients would experience in SB8 lawsuits. It means that, you know, even if a doctor were willing to provide abortions in violation of SB8, and notwithstanding all the barriers to that provider would be putting their patients at risk of their names coming out into the public through this discovery process. It's all very backward, obviously punitive in many ways, and obviously plays into the shame and stigma associated with abortion access in Texas and elsewhere.
We have another question about if Roe isn't overturned this year in Jackson Women's Health, or if it's not pushed back, but maybe is in a future year, would that resurrect SB8 if enjoined on grounds of unconstitutionality previously, and impose penalties retroactively on providers who have provided abortions? And I think this kind of dovetails with another question someone had about what happens, the retroactive application in between being enjoined.
I guess that's for me again, but I think one of the most pernicious aspects of SB8 is this retroactivity provision, which says that even if an injunction is entered in a case, basically a provider couldn't rely on it because if it was later overturned or amended by a higher court, then the provider could be liable for abortions provided during that time. Now, that provision itself is extremely constitutionally suspect for a number of reasons. Our system of laws don't work that way. You have to know what the law is at the time that you are acting under it. Otherwise, how can we function as a society? But that provision in particular has had an extremely chilling effect on providers and advocates in Texas who who are just seeking to do their jobs and provide constitutionally protected healthcare. I will note that the justice who seemed the most troubled by that provision specifically during oral argument on November 1st was Justice Kavanaugh. So hopefully I take that as a sign that this sort of scheme, is obviously used to target abortion rights in this case. But if it is blessed by this Supreme Court, it could be used in really damaging ways towards any constitutional right that's disfavored by the legislature of a state.
Great, thank you. And I have just a general question for all panelists. In the terrible event or a future we don't all want to imagine, but one where we don't necessarily go back to pre-SB 8 days. What does accessing care look like, or providing services or for other folks from each of your perspectives? What does that look like? How would that change the work that you do, and maybe the work that folks as abortion advocates as a whole, providers, people working on the ground to change legislation, and people in courts? Like, how would that shift the ecosystem in the future? And feel free to jump in, anyone. It's a broad question.
All right, so which future? Explain your hypothetical again.
My hypothetical, yes, I'm in law school, so I'm functioning on a lot of hypotheticals these days. But assuming Dobbs versus Jackson Women's Health pushes the line back, doesn't hold the line, and we're in a future where pre-viability abortion at a certain point can be banned. What does that look like for folks in Texas where we already have this lack of access to care? What does it look like for the work that you do? If in the future access is going to be limited to 6 weeks, 8 weeks, 15 weeks, whatever that might be, we still need to get folks care presumably past that time. So how do we do that?
Yeah, I'll just say, unfortunately, we sort of know what it looks like, right? We saw the complete ban in the early COVID days, and we see what it's doing to patients now when the limitation is at roughly 6 weeks, and it involves a ton more expense and a ton more travel and hardship for the people that just need healthcare, and it involves a ton more, private money and support. That those travel dollars come from funds, practical support funds. It means a lot of people, unfortunately, that are going to carry pregnancies to term that they would have preferred not to, because that is not an option for them. They can't travel for whatever reason, and that's mostly the people who have the fewest resources, including young people who have to go through a judicial bypass process or can't get away from their house to get a procedure.
Yeah, and immediately pre-Roe, we already had that scenario, right, where we had abortion haven states, Colorado, New York. There were a couple of others where abortion was accessible, and then once Roe was passed, or was there, the law of the land, the landscape looked different. So we're really going back in time where we'll have states that are abortion haven states, and we'll have abortion desert states, and folks will travel. And also, I think the number of clinics in abortion desert states is going to go down to 0 if that's the route that they take, and other states will start to see more clinics and shifting of providers that are able to shift. But to move a clinic, or for a physician to just sort of pick up and be like, I'm going to go to this state now, that's not an easy decision. So I think things will settle with time, but it's going to look very, very different as far as the landscape of not just abortion access, right, but like outcomes with folks who are pregnant. And again, going back to maternal morbidity and mortality, when somebody is pregnant and they can't get out of the state, and they have very serious health reasons why they can't be pregnant, we're going to see those outcomes. And states like Texas will continue to have very poor rates of maternal mortality and morbidity, and other states like Texas will do the same thing. And we'll see some very stark disparities, I think, throughout the country.
Right. I mean, I'll just add, obviously we're already seeing what this looks like, but in the hypothetical you described, the role of abortion funds and practical support networks will only become more and more important. And the need for supporting those groups now and in the future has never been more critical. On a practical level, what are we going to see? Well, young people, undocumented folks, people in detention simply will be forced to carry pregnancies against their will. That's what we know will happen. Pregnant people will die. Pregnant people will be imprisoned for pregnancy outcomes, whether they're their fault or not. It's a scary future that we're looking at, but what I can say about the folks on this call, because I've been working with them for years, is we're a creative group in our community and we won't go away. We will shift gears. We will do whatever we have to do to help pregnant people get the health care that they need.
I'm so glad you've shifted to a more positive note, because I wanted to end on one, and I also wanted to end by letting folks in the audience know how they could get involved and how they can help. So I don't know if there are pro bono opportunities that folks have, or other ways to get involved that you want to speak to really quickly before we close out.
I mean, in terms of pro bono support, while support from the business community has been somewhat disappointing, support from the legal community since September 1st has been really, really heartening. So you can reach out to me. We have a growing list of pro bono attorneys in Texas and elsewhere who have volunteered to help with SB 8 cases and to help with the work going forward. But continue to tap into your networks. Diamond Brown, who helped organize this event today, that's her job, is to help connect attorneys across the country who are interested in helping support abortion access, to get connected to the organizations and the plaintiffs and the folks that need assistance. Because I think what we know is that in the short term and the long term, the need for lawyers in this space is not going to go away.
In Texas, if you're also looking for other CLE hours and want to do pro bono work, the Jane's Due Process CLE is online. It's 2 hours of CLE that will help you learn how to navigate the judicial bypass process in Texas. So you can get that CLE and then sign up to be part of our referral network, and we will help connect young people that need help with you to get competent representation in those cases.
Well, I want to thank you, Zoraima, for moderating an incredible panel. Thank you to Molly Duane and the Center for Reproductive Rights, Dr. Kumar, Planned Parenthood Center for Choice, and Blake Rocap at Eval and Jane's Due Process. You are doing amazing work under horrible circumstances, and I hope that our organization can help you. And I hope that our members have gotten some good info and can follow up on the ways that they've told you can help. Because obviously everybody needs to be in this fight. Thank you each. And we will see you all on December 1st, and we'll have somebody give us a quick recap on the abortion argument from that morning in the Mississippi case. Do you have any closing remarks, anyone?
No, thank you all again for all your work.
All right, thank y'all. See you next time. Bye.
Bye-bye. Thank you.